Breaking news out of Buffalo, New York today. Federal judge in the Western District of New York, Judge Sinatra, just enjoined, which means stopped, New York from enforcing their ban on guns in places of worship in the counties covered in and around Buffalo, New York. A huge win for the Second Amendment and a precedent-setting one that will likely have ramifications far beyond the parts of New York that are covered by this decision. Stay tuned. I'll tell you all about it in 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. Major news out of Buffalo. In his decision, Judge Sinatra says that the gun bans on places of worship, specifically churches, synagogues, and other places where people come together for religious services, that is unconstitutional under the Second Amendment and under the framework of Sinatra versus Bruen. Judge Sinatra in the Western District of New York specifically says that obviously banning guns in so-called sensitive places like churches and like synagogues and like other types of places for worship is unconstitutional under the Second Amendment, and therefore New York may not enforce it, at least to the counties that are governed by this case, specifically the defendants and the state police and the like, who are enjoined from enforcing this law. Now, what's very interesting here is that the Judge Sinatra, specifically points out that the ban on guns in places of worship falls well within the ambit and the text of the right to keep and bear arms of the Second Amendment. And as a consequence, it was the burden of proof that got shifted to the state of New York and to the defendants to demonstrate that there were historical analog laws in 1791 to uphold the modern day ban on guns in churches and places of worship. And Judge Sinatra said the state cannot meet its burden at all. There were no examples that the judge cited in 1791 that he could find articulated by the state of New York. In other words, there's no 1791 ban on guns in churches or places of worship. So at the time of the founding, there is no historical analog. We could have told them that, of course, because we know, if anything, at the time of the founding, there were sometimes obligations to bring guns to churches. And there were certainly never bans on guns in churches in 1791. So what did the state do? Well, they tried to do their sleight of hand, which we've talked about in this channel before, in an article I have forthcoming. I've already published it. It's coming in a big law review. I'll talk about that in a separate video. But a detailed historical explanation explaining that under Supreme Court precedent and beyond, there's no doubt that to interpret the Second Amendment properly, you have to look to historical analogs in 1791. Anything after the Civil War in the late 19th century is simply not allowed. It is too late. And that is exactly what Judge Sinatra said. He's obviously a brilliant judge, right? So Judge Sinatra said that if you look at the examples of gun bans in places of worship, the only thing that the state of New York allegedly cited to were four. Specifically, gun bans in 4 places: Texas, Missouri, Virginia, and a couple territories. That's all they had. But the killer point in favor of the gun rights movement, as Judge Sinatra pointed out, is every single one of these alleged historical analogs were way too late, because they ranged in enactment from 1870. That's 1870. That's years after the Civil War ended. So from 1870 to 1890, you had examples of these gun bans in churches, supposedly, but nothing in 1791. And Judge Sinatra said, literally, this is way too late to help me understand the meaning of the Second Amendment. It is not allowed. And he rejected the state's efforts in this regard and tossed them out. Beyond that, I should also make another observation, is he did kind of allude to the fact that these states, to the extent they existed, might even be outliers. Because remember, I got to remind you of one critical thing. This is very important. When you interpret whether or not they're historical analogs to justify modern-day gun control laws, okay, there's something I want you to remember. This is the Supreme Court's test in Sinatra versus Bruen. Here it is. I'm going to quote the Supreme Court. This is not my interpretation. This is the Supreme Court itself in Sinatra versus Bruen. Quote, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. No balancing test, right? We talked about that. No tiers of scrutiny, no balancing test, right? So the regulation promotes an important interest. Rather, back to the Supreme Court, rather the government must demonstrate that the regulation is consistent, this is the key language, I want you to remember this, consistent with this nation's historical tradition of firearms regulation. The point is that whatever the state proffers, it has to be consistent with the nation's historical traditions of firearms regulations. It cannot be an outlier. Outliers are no good. Outliers are like needles in a haystack. They're one-offs. They don't count. You have to look at a long-standing tradition, something that's actually a tradition, which means it's long-standing and has occurred over a long period of time in many, many instances, to say, and there is certainly no long-standing tradition of banning guns in places of worship in American history at any point in time. Not even in the late 19th century, but that's not even the relevant time period. So that is the standard. And what this judge specifically said is, for all intents and purposes, the examples the state came up with, and they spent a lot of money because there's some very powerful and very smart organizations submitted amicus briefs on behalf of the state of New York, including Everytown for Gun Safety. They're very smart, very good lawyers. They have a lot of resources, a lot of brains there, and they could not come up with anything better than those examples, those historical analogs from 1817 to 1890. That's the best they came up with. And in my opinion, they're really some of the best lawyers that the anti-gun movement has. And if they couldn't come up with anything better than that, then I think that bodes well for the future of gun rights in America under the NYSERDA versus Bruen standard. I should also mention, this is also quite interesting, that the state indicated that they would like the court's decision to be stayed, which means the decision to strike down these laws to be stayed, meaning not to go into effect, to give New York the time to appeal to the Court of Appeals for the Second Circuit. And the Judge Sinatra says, no way, no how. He denied the motion for a stay. And I think this is very powerful language that I'm going to quote to you from this decision. And this is what Judge Sinatra wrote, very powerful. He says, legislative enactments, what we're talking about with what New York did, legislative enactments may not eviscerate the Bill of Rights. Again, legislative enactments may not eviscerate the Bill of Rights. Every day they do is one too many, close quote. Judge Sinatra, powerful language. He recognizes that every single day your Second Amendment rights are violated. It is an irreparable harm to you. It is a violation to the Constitution. It is a violation to the morality and reality and constitutionality of American law. And he recognized that with that powerful, powerful quote. And I applaud him for doing so. And the last point I want to make about this order, we can talk more about this later, but the last point I want to make is this. This is another thing that Judge Sinatra said, and I think this is going to be extremely important for a reason I'm going to explain to you that's not obvious, but it will be when I explain to you, and you'll get it as soon as I do. Here's what Judge Sinatra talked about in describing places of worship. He said, quote, in particular, places of worship and places of religious observation are unsecured spiritual places that members of the public frequent as often as a daily part of day-to-day life and encounter vast numbers of people there, as they do anywhere in public. And he points out that that's fine, but you can't ban guns there under the Second Amendment. And the reason why I think that sets a major precedent is one of the things that the anti-gun movement is trying to do with their sensitive places. And remember, sensitive places is a euphemism for government-mandated gun-free zones. When you see sensitive places, all that is that the government is banning guns in a particular place. That's all it is. And the Supreme Court says there are some very narrow examples that are allowed. Polling places, legislative chambers, and courthouses. Obviously, churches and synagogues are not part of this. But let's be very clear. The one argument that the anti-gunners are trying to develop, and I don't think it will work, is they're trying to argue that any place that has children, or large numbers of children, is somehow a sensitive place. That is an argument for it being a sensitive place. It is simply not historically true, by the way, for many reasons, but one of which is exactly what Judge Sinatra said. Certainly children go to church, children go to synagogues, children go to mosques, they go to places of worship all the time. So the mere fact that children are in a particular place does not make it a sensitive place. It's not even relevant to the sensitive place analysis, in my opinion. But anyway, the bottom line is huge victory in Buffalo. I want to congratulate the organizations that brought this case. The individual Jimmy Hardaway Jr., Larry Boyd, the two religious leaders up there. They brought the lawsuits. Congratulations to both of them. The Firearms Policy Coalition, of course, and the Second Amendment Foundation, both wonderful organizations doing great work and great job in litigation. And this is a major victory, again, for not just those plaintiffs that I just named, but for everyone that supports the right to keep and bear arms in America. And I'm extremely excited to bring this wonderful news to you here at the Four Boxes Diner. So hope you learned a little bit something. eating at the Four Boxes Diner. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.